in the Supreme Court of Canada, clerking for Madam Justice Deschamps. And the Supreme Court liked him so much that they hired him to be a lawyer in the Supreme Court for 3 years. With that kind of a background in Canada, he could probably work in any law firm, both either in Hong Kong, in Canada or in the U.S. I know many of your colleagues went on to work in New York, but instead he chose public service, and he chose to work for the government of Canada, and of all places to work, he chose to work in the northern part of Canada. And he's here to tell us about some of his interesting experiences and insights from this rather unique kind of legal practice. Mr. Lafrance.
Thank you very much for this very generous introduction, and thank you very much, Professor Young. So today's topic, first of all, is a short preamble. I just would like to tell you that I'm currently a Crown Counsel for the Public Prosecution Service of Canada, so anything that I will say today is not binding either in the Government of Canada or the Public Prosecution Service of Canada. I'm here. Yes, I will talk to you about my experience in the north and the cold and the snow. But that will be from not my personal perspective, that will be the law, also some personal insights and heads up about what's going on in the Arctic. But I just wanted to tell you about that short preamble before we start. First off, as you see on the PowerPoint or the board, the Arctic is quite unique. In terms of geographical isolation, there's plenty of different small communities, and that are covering 20%. None of it covers 20% of Canada's territory, which is pretty big. So none of it is on the right part of the map there. And where I worked for almost 2 years, and on the left side of the board, you'll see the Northwest Territories, which is pretty big as well. So first of all, what it means in terms of legal impact and the practical aspect of it. So I will give you a break today about big, complicated, fancy legal theories. I will touch upon them, but I would like to provide you with more of a practical background about the Arctic, more than delving into fancy intellectual details. And then we'll touch upon at the end about some more intellectual ideas. So whenever you have a question, I please invite you to interrupt me at all times. Just raise your hand and ask me to answer one of your questions. If you have any, I will be happy to answer them. So what it does mean in terms of practice in criminal law for Crown Counsel and Defense Counsel is, in the first place, in the Northwest Territories, there are a few courthouses. So I was talking with Professor Young about it earlier, about that, but that means Crown Counsel and Defense Counsel, the court has to sit and be held in unusual places, to say the least, as community halls, school gymnasiums. So it gives a really good, and it puts you back on track, and it gives you a good reality check, and it may involve some practical challenges from time to time in terms of perception of justice. For example, I was talking about that to Professor Young earlier, but I experienced recently, I was in a courthouse where the proximity with the judge could have been a problem, right? Because we were really close. It was a small, not a community hall, not a gymnasium, but that was a smaller place, which was in a private or public building. So we managed to organize things out, to set things out, but this is the kind of things that you don't experience in what we call the South. So what the South is, the tropics for the people in the North, and I call it myself. I am first of all, when I first moved to Nunavut, which is on the right side, which touches the green. It doesn't geographically touches it, but it's close to. Oh yeah, yeah, thank you. So if you look at here, it's really close to Greenland. So it involves practical challenges as well. Flying to these small places, and calling that, I was talking about calling the South. So when you're in these two places, so the Northwest Territories here and Nunavut here, so these 10 provinces, these tropics of Canada, the 10 provinces of Canada, we call it the South. I was surprised when I first started in Nunavut. I was a bit surprised that these guys were calling the 10 provinces, which is still in the north, right? But still surprised by people calling it the South, but I do it myself on a constant basis since I settled up there. So, we'll move on to the next slide here. So, being in the North, it provides a unique cultural and geographical setting. What is sad, and you need to know, and it has a legal impact, and we'll come to that a bit later. What is stated here, and that's a reality that happened in the North. Under a policy what's written under a policy of forced relocation, both Inuit and Innu were removed from their ancestral homelands and traditional hunting territories to form centralized settlements created by the government. So, all of which to say, many Inuit from the northern Quebec, which is here, I'll show you the map so you will understand. So northern Quebec, which is here, where they were forced to relocate a lot further north up here. So many Inuit were forced, they didn't choose it, they were forced by the government to relocate to, for example, Grace Fjord, which has a really small population. Why? That's an assertion of sovereignty, right? Canada wanted to assert and make sure we were in the times of the Cold War. The Americans and the Russians were really, the atmosphere was pretty tense. So Canada decided to relocate a lot of Inuit from Quebec and force them to relocate up north. So what impact does it have on criminal justice? Well, many of them were traumatized, rightfully so, by this experience. When you grounded your roots in a place, if you were forced to relocate from Hong Kong, where it's pretty warm and nice actually, to Yellowknife, where it's getting colder and colder, would you be happy about that? Probably not, right? So moving from your homeland that you live on for generations to a place that is totally unknown, to a smaller place where it's cold, freezing cold, where food is hard to reach and obtain, so that causes a trauma. And in terms of criminal justice, I'll tell you the punch right now, and we'll come back to it later so you're not taken by surprise, but in terms of criminal justice, there's a section in the Canadian Criminal Code, which is section 718.2, subsection E. So basically what this section provides is that the aboriginal reality has to be considered when the case, when the accused is found guilty, or where he pleaded guilty. By the sentencing stage, the aboriginal reality has to be considered when giving a sentence, or when the judge renders the sentence. So what's the connection with what I just told you and this? The sadness, the sorrow of being relocated, forced to relocate, and also we'll see it here. Just bear with me for yes, here. There's something else. There's another issue that adds up to all this. It's the trauma that the Aboriginal population went through the residential schools. So the first quote here the impacts of forced removal of children from their families, not what I just talked to you about, the fact that they were forced to relocate to assert the sovereignty of Canada, but the fact that children were abused in residential schools have been passed down generation to generation. So this is something else. Many Aboriginal people were forced to forget about their language, to forget about their culture by the priests who take care of them several decades ago. Recently, the Government of Canada apologized for that. There was an official apology from the Government of Canada. And it was a widespread abuse. It was not an isolated abuse. So when there is this section of the Criminal Code that says that the reality of the Aboriginal people has to be considered when giving a sentence from the judge, it's not because, we're going to consider that they're rich, famous, and happy. No. It has to be considered as a mitigating factor. The fact that they went through such traumas from generation to generation. So practically speaking, when the judge renders a sentence, if a person, for example, a youth or a young adult, has parents who were abused or grandparents who were abused in residential schools by mainly Catholic priests, the judge will take that into account. That will play a role in as a mitigating factor when giving a sentence. So instead of, and we'll touch upon that issue later on, but instead of imposing a sentence of jail, something else might be imposed. So the Supreme Court of Canada and the decision Gladieux, that we'll see a bit later, the Supreme Court of Canada stated summarily that the more, when something else does exist, something else than custody, than jail, when Aboriginal offenders are before the courts, so this must, not should, not may, it must be considered by the judge who gives the sentence, who imposes the sentence on an accused. And why? Because of the over-incarceration of Aboriginal people. And that's a connection with what I told you at first. Going through such trauma, being forced to relocate, to a large extent, not a couple of people who were told to you, oh, well, you'll have a nice experience in igloos in the north. No. A large part of the population, Inuit population in Quebec, were took away from their roots. In addition to the abuse, the large abuse in residential schools, it does have an impact on the sentence. What else that is unfortunate that happens in the north is the large amount of spousal and sexual assaults, more than anywhere else in Canada. So the Northwest Territories and Nunavut has the highest crime rate in the country. Again, why? Well, this is not the law, but common sense will tell you when you go through such horrible stories, and many of them, I know a couple of people who personally went to residential schools who went through such abuse, and leads to what? Leads to desperation, leads to constant sadness and sorrow, leads to abuse of alcohol. Why? Because you want to forget about it. You just don't go out and take a walk and, oh yeah, just forget about it. No, that's huge. That abuse lasted for years and years and years. And when you're forced to forget about who you are, the language you speak at birth. Because in Nunavut, for example, they speak Inuktitut. Most of the population do speak it. They also now speak English. And why? Because they were forced to forget about the language. So when you go through that kind of traumas, well, has an impact. You are more likely to commit crimes. And even though as a person, it is your fault because you practically did it, there is some social explanation that doesn't justify the action, the crime you did. but may explain that hence the mitigating factor, which may explain why you were led to such a bad action. So in Barré-Jean in 1986, the Northwest Territories, the Supreme Court stated that spousal assault is no less serious because it occurs in a Dene village rather than a depressed or even affluent section of Toronto or Halifax. Leads me to one of the cultural differences and some prejudices that the white people may have against the Aboriginal population in the North. That's part of their culture excuse. Yeah, violence is part of their culture. They have a tough living. They live in the cold. It's hard. So spousal assault, sexual assault, it's part of their culture because that's the way they deal with things. But it's not. So that statement from and I expanded it a bit, but this is why, or this may be why, the Northwest Territories Supreme Court said or insisted on the fact that, well, spousal assault is as serious as it is in the North as it should be considered in Toronto or Halifax. So it's not saying, no, they're not different from us. It's not that statement, but it's to tell them whatever abuse happens, that's an abuse. And there is no cultural excuse to it. And as I said earlier, the sexual assault against women is particularly prevalent in northern Canada. But again, like it was stated recently by Judge Shaner, again from the Northwest Territories Supreme Court, the need to discourage violence in Aboriginal communities is just as important as it is anywhere else, right? So it leads us to the same or similar statement that was made at the same court in back to 1986. So about the application of the criminal law in Canada, so you have to know so the criminal code applies in all jurisdictions the same way, but there are some variations when it comes to the applicable procedure in various provinces, but only the procedure. So section 718.2 subsection E of the criminal code, the Aboriginal reality, that's part of that different procedure that the the court, I don't remember, the Supreme Court directly talked in length about that section, but this is what it means. So Canada is such a huge country that even though it was stated or recalled by Judge Marshall in 1984 that there was only one criminal law for all Canada, for all Canadians, so one system of law applicable, a criminal law applicable to everybody, there are some differences. And the Aboriginal reality attracts or brings up differences in terms of criminal justice, for example, when it comes to sentencing procedures. What is also interesting, though, and I will move on right away to this, is the presence of the elders in the judicial procedure. In Nunavut, for example, and he cited a couple of times, not a couple of times, what am I saying, many times, elders, so people from, old people or senior citizens from the general population, could be anybody, but usually it's people who are respected in the small communities, are relied on partially or entirely, or it's not known because the judge does not have to justify himself or herself on the record about it. But the elder will talk about the accused, the family, the impact of the crime in the community. And the judge will take that into consideration when rendering the sentence to be imposed upon the accused. Is that something that exists in the South? In the other provinces of Canada, the 10 provinces? No, it does not. But why is it so? Why is it used in the North? Well, certainly to show some kind of empathy, or legal, let's say, legal empathy, if that expression may exist, or integration, but this word is really loaded, so I'm really careful about that word, but this is a way to pay respect to the Aboriginal population and say, well, you will be included in the criminal procedure, not only as accused, not only as victims, but also as deciders or decision makers, right? Which is not the case elsewhere in the country. So it's only in Nunavut, a bit less in the Northwest Territories. I didn't see it so far, but it must be the same, right? And why elders? Because they don't, Inuit, and then they don't have codes like we do have in Canada and many countries. They'll have a book that's called the Criminal Code or the Criminal Law, whatever it is. The knowledge or the traditions are passed or were passed orally. So the elders are the well-respected people, are the people or the messengers of the traditions of the community. So the tradition, for example, that's really interesting in terms of how criminal law was used and applied. So first off, did Canada integrate fully by relying on the elders for rendering a sentence? Did they integrate totally the previous system of law that was used by the Aboriginal population? The unfortunate answer is no. Canada can be, and that's reported in some articles, the Canadian criminal system can be tagged or qualified as having rejected the Aboriginal system of law. So a way to maybe put a balm on the wound a bit is to use in a good way, use the elders, at least, in the criminal process, without relying on the traditional system. And I will move on and show you differences between the white, so-called white criminal system of justice and the traditional Inuit system. So it's pretty small, so I will zoom in. Okay. So bear with me for a second. Oh, yeah, that's right. Excellent. Thank you very much. So, living in the north means that I'm not a techie. For example, in the Inuit traditional system, so no, the Inuit nowadays don't work and don't rely on this system anymore. They tend to lose it more and more, and they don't impose, at least officially, these sanctions, these punishments. But insulting someone was considered to be an offense. The same for failing to share food, and that's the most interesting one here. The poor or lazy hunting or failing to share food was considered to be an offense. Why so? Why sharing the food? And it's not. There is no section. You can look for hours in the Canadian Criminal Code. The fact that I didn't want to share my plate with my sister when I was a kid, I cannot be convicted for that. Thank God. But in the Inuit traditional system, you may be not convicted as we understand the criminal justice system, but there was this traditional offense of failing to share food. Why? Because, like I told you in the first place, these communities are small. That's the north. It is cold. It is hard. Life is tough. So you don't have this big, well, more nowadays, but in the older days, you didn't have these big, huge supermarkets where you can just show up and show your debit card and buy plenty of food for nothing. Even nowadays, the food up there is very expensive. So failing to share food when you have to stick together. So it has an impact on criminal law to that extent. Because the Canadian Criminal Code, if you fail to share food, if you are in Toronto, Halifax, Vancouver, which are the big towns in Canada, people will laugh at you. And if somebody shows up at the police station saying, well, Mr. Police Officer, my sister didn't want to share food with me. I'm really upset. I would like her to be charged. I would like to testify about it and make a statement about it. The police officer highly risks to laugh at you directly in your face. But the way the Inuit lived and in small communities, and they still do. There are so many communities in the north in small places. They have to, and they had to, and they still do have to collaborate and be helpful to each other. So that's one of the major differences. The theft or property also was dealt with. That's something here. Leads us to shoplifting mostly. Yeah. So this is the continuation of what I was talking to you about. So Griffiths and Patnaud wrote that in native Indian and Inuit societies, an individual could take and use whatever he was required and then give back the article when the task was completed. So the owners of property were under an obligation to share, that's the key word, with other members of the group. So if you or I show up anywhere and pick up, I don't know, chocolate bar in a store and say, well, I'll give it back, you're just going to take a bite and I'll bring it back to you later. No worries, it's fine, I'll bring the rest of it. I'm not super hungry, but I'll bring it back to you. They are not going to tell you it's okay, even though it's only a chocolate bar. They will call the police. So for Native Indians and Inuits, this is something that I still saw as being a foreign notion, concept. Even though they understand what the criminal law is and when they're charged with picking up something, but they understand rationally, but it's not a given. It's not something that's being fully understood as being obvious. So they share. They do share a lot. And they needed to for survival reasons. Because if you don't share food, if you have a lot, you went hunting, for example, and you have a great big caribou that you bring home in the back of your skidoo, whatever it is, or the dog sled in the older days, you're not going to eat it all for yourself. Why? You have no fridge. They had no fridge. They had no stove. So you're going to share the food with the family. And this is why also you expect to get it back. So there's this kind of ongoing collaboration, cooperation that is part of the Aboriginal and mostly the Inuit tradition lifestyle. So even nowadays you hear that, oh, somebody went to hunting, so the senior citizens who can benefit from it. So the young people go hunting, will go fishing, and you will even really often hear that, oh yeah, we'll share with this grandma or this grandpa. They're not necessarily related to their family, but they will share for free. So property doesn't have this restricted, narrow-minded notion that we are dealing or faced with every day when we go to the store. So that has an impact in terms of criminal law because of shoplifting, because of property offenses. Break and enter, for example, that's something that's pretty, well, common. Not common in terms of the daily life, but in terms of the number of criminal offenses in the north, there's a lot of break and enter. But that's something else, that the house of a person was, the sense of property was not that enshrined, shall I say, or printed in the culture. So you can show up and come in somebody's house if you're freezing out and just want to get warmer, so get in. You don't need to be invited, you just want to warm up. Of course, some people are, they want to steal from other people, and of course the intentions are not always good, and it's not only to warm up. So I'm not here trying to justify them and say, yes, they're all good, it's all okay, but sometimes it is. Sometimes it's not for bad reasons that they do it. It may be, it is sometimes, but you have to draw a line, which we don't usually. If someone comes in your house tonight and you don't know him and he just sits on your couch, the only one reaction you will have is to call the police. But in their cases, in the case of Aboriginal population and the Inuit, it's not necessarily the case. It's not necessarily to steal something, to rob you, to punch you, or to harm you. Maybe it was just to warm up. Maybe not, but maybe. So that's a cultural difference that has an impact on the criminal law system, right? Because when we talked about the mitigating factors, the Aboriginal reality that, and I talked to you guys about Gladue, the decision of the Supreme Court of Canada. I will jump to that right now and come back to the other issues later. So I talked to you about it earlier. So the Supreme Court of Canada in 1999 stated that the excessive imprisonment of Aboriginal people, why are they over-incarcerated? We talked about it, we covered it a bit, because of the, not only because, but partially because of the cultural differences, partially because of the residential schools, partially because of the abuse of alcohol. So when you're totally drunk, you're more inclined to commit crimes because you're not aware of your actions necessarily. Because of the sexual abuse of all these guys in the residential schools that I also mentioned. So the Supreme Court of Canada stated the excessive imprisonment of Aboriginal people is only the tip of the iceberg insofar as the estrangement of the Aboriginal peoples from the Canadian criminal justice system. The Aboriginal people are overrepresented in virtually all aspects of the system. So, like I said earlier, I'm not trying to justify and say, yeah, it's all good, but at least you will know that because of the cultural differences, also because of the trauma that they went through, the Aboriginal population of Canada and the Inuit also, or the Dene, D-E-N-E, the Dene population in the Northwest Territories, which is a different group of Aboriginal people, well, there's not necessarily justification, but there is an explanation for it, for the crimes that were committed. Also, and that may be a controversial statement, so I'll clarify it with you right away. So Griffiths and Patnaud also stated that the native Indian Inuit went from the Stone Age to the Space Age in the short span of 50 years. So this is not, and I must clarify it here, this is not a racist statement. What Griffiths and Patnaud, they don't say that, well, they were so, between quotes, uncivilized before, and oh, wonderful, they're so amazing today. No, this is not what they're saying. They had a traditional lifestyle. They used to live on the land, and now they are living according to the Westerner standards, more and more. So the last person living on the land died a couple of years ago when I was living in Nunavut. So they are getting more and more westernized, shall I say. So they're, not only that, but they forgot, like I said earlier, their language and not their culture, they're proud of their culture, thankfully was saved and preserved. But according to Westerner standards, they went from the Stone Age, according to these standards, to the Space Age in less than the short span of 50 years. So that's something else too. When you're used to a complete different lifestyle, not one thing that you have to do differently when you have to immigrate to another country, for example, well, obviously the food's going to be different. No, everything's going to be different. Not only the language, not only the culture, but the way people see and approach things, including crimes, including the justice system. So that's a big difference. And like I said earlier, this is what it shows here, some stats for the lovers of numbers, which I'm not. But the Northwest Territories and Nunavut have the highest, not only high, but the highest crime rates in Canada. That's quite unfortunate, but like I said earlier, there's an explanation, at least partially, for it. So as noted by Griffiths and Patnaud, there's the extensive abuse of alcohol and other difficulties, changing from a lifestyle to another, being forced to forget about your mother tongue, and moving on to a culture that is not yours, that is imposed on you, being forced to relocate from one spot, which is your homeland since generations, to an unknown place just because the country you live in wants to make sure that another country will know that the Canada is there and assert its sovereignty. So so that may be included in the other difficulties here mentioned by Griffiths and Patnaud. So this is one of the legacy of the colonization of the North and its people by Euro-Canadians. So we basically turned everything upside down. And when I say we, I say the white people, by not invading them, but imposing them, imposing standards on them that were totally unknown. So what I'm saying is, I'm not telling you guys that didn't have a clue about the law, didn't have a clue about justice. Yes, they did. But their ways of dealing with the criminal or offenses were different. We saw the table earlier where I brought your attention to insults, for example, that has no bearing in the criminal code. So Justice Kilpatrick from the Nunavut Court of Justice said something very interesting here. This is the second quote. In the Inuit communities of Nunavut, respect for elders remains, and this is the keywords I want to bring your attention to, is a core social value. And I was even myself surprised so many times in Nunavut to see in court young people, young offenders who committed sometimes horrible crimes, sometimes crimes less important, but who paid respect so much every single time to elders. This is a cultural difference too. That's unfortunate, but many white Canadians, I can say, tend to put their old people in house and little senior citizens' place and forget about them and pay a little rent and, oh yeah, they will die one day. No, the Aboriginal and Inuit don't have that, which is a positive thing, right? And so my statement here is the white people has also many things to learn from the Inuit culture. So it's not only the bad side or the wrong side of the medal that the Canadians have to. It's not only when crimes are committed, but also there's so many things to be learned from them, like the respect for the elders, for the white Canadians, for example. That should be also be the same thing for us, and that's unfortunately not the case for many people. It is for me, don't worry. It's the pictures that you see on the board there are all of them are pictures taken by myself. I took them, so here you see that's the funniest. That's the only one I've seen in Canada so far. That's a little road sign that shows that be careful because there might be dog sleds passing by. So you see dogs on the road sign. It's not a joke, it's a real road sign because this place, dog sleds pass during the winter. So that's in Iqaluit in Nunavut. The picture's been taken in 2014. So you see that's, it's a world of discoveries. Something else to go back to something a bit more serious is the existence that I mentioned earlier of the circuit court. This is why it's called, how it's called. Circuit court is the fact that justice is provided to most, if not all, almost many, all of them in the communities in the north. That's something that goes back to the 50s and the 20th century. So, like you see, there's a picture here that I took recently, a couple of months ago. That's an example of a court. That's court. It's not a permanent court, but that's a courtroom, temporary for a couple of days and for the resolution. So this is where my finger is. That's the Crown's table, and you have the defense counsel table here, and you have the judge's table here, and the court reporter and the court clerk sit here. And you don't see it, but it's a place made or built with logs, wood logs, so it's pretty typical and nice. But summarily, what I can say about that is because of the absence of courthouses in so many communities, justice is not taken for granted. So justice is not there and available at all the time. Well, it is with police officers. We'll talk about it a bit later, but justice comes to you. Court comes to you. And this is what the circuit court system wanted to tell the native population and the Aboriginal people. So they don't have to fly down all the time to the big white towns and cities to have justice served. No, justice will come to you. The courthouses will come to you. And for example, the elders will usually sit here because the elder sits right next to the judge. When the elder gives his impression about the accused, for example, and what he thinks about the family, the crime that was committed, the importance of the rehabilitation, I will move on to that aspect right after. This is where he sits. So that's a big symbol. So the elder who gives or who says what he thinks, what the sentence, not the sentence should be, but what is the background reality of the community, sits next to the judge. Not besides the Crown, not besides defense counsel, but next to the decision maker. So I talked to you, I mentioned the existence of rehabilitation. Of course it exists in many, if not all, criminal law systems. But the traditional Inuit system, for example, didn't have a clue before about, it's not, they didn't have a clue, I'm sorry, but deterrence and denunciation of a crime was not the primary focus. Why? Because it's so small. So if we punish everybody, in the older days and even nowadays, why punishing in so small communities? Because everybody is a brick part of the wall, or the bigger and the greater scheme of things. Every single person matters. For things to work out, we need everybody, because it's so small. So if we punish everybody for small crimes to murders, well, we're going to have a big issue. So rehabilitation, not only for that reason, but that's one of the reasons, rehabilitation plays a major role in the traditional Aboriginal people system. Contrary to the white traditional, so not traditional, but the white criminal law justice system, where deterrence and denunciation is, and that's also mandatory for many offenses in the criminal code, deterrence and denunciation are, or may be, the primary focus. So that is another cultural difference when it comes to the criminal law as applied by white people and by Aboriginal, traditionally at least, or by Aboriginal people and Inuit people. So something else about the, it's quite interesting here. Not only that, but the, like Griffiths and Petnote noted, the adversarial framework. So basically having a Crown Counsel will argue for the Queen or the state, and the defense counsel will represent the accused, and they will argue one against the other. That's something that is foreign to the people of the northern communities. So even the terms, the terminology that is used, for example, and I may be wrong in my translation about it, but I was told at least that the Crown Counsel, the people representing the Queen and the state, was translated in the Inuit language at least one time when I was there in court as the person who put people in jail. Well, I was the Crown, and I was not asking for a jail sentence in my submissions. That's not what I wanted. So being tagged as a person, oh yeah, that's the guy who's going to put people in jail. So when you come to a town, you're not really welcome by these guys. So when it's translated, so words matter. Words make a difference. So this job description also, as you can see now, makes a huge difference. So they try, and they still try, I guess, maybe nowadays to have a better translation for it. But not only the framework, the adversarial framework that we use to, we take it for granted. We saw many shows on television from the US. Yeah, there's the prosecutor or the Crown. If you're in the Commonwealth prosecuting someone, this guy is going to be defended. No, it doesn't work that way. And the Inuit system, it didn't. Has to, because why? Because the criminal law system is imposed on them. We saw it earlier. There's a decision in 1986 that I referred to, I quoted here, that said that the criminal law has to be applied all over the country. So what it does, it rejects, right? It's a total rejection, as reported by the authors, but it's total rejection of the traditional system of the Aboriginal people in Inuit. So something else to really briefly to be mentioned here is the numbers of justice of the peace. So justices of the peace are usually the decision makers for bail hearings or release of the accused. When someone gets arrested, he's brought before a justice of the peace, and the justice of the peace will hear the Crown Counsel's submission, the defense counsel's submission, and the accused will be either released or kept in custody or put in jail by the guy who put people in jail, like I told you. So more and more JPs tend to be, it's not necessarily the case in the Northwest Territories always, but still in Nunavut, at least there is one, it's very good. They want to integrate Inuit not only as accused, as victims, but also in the judicial system as main actors on the bench, as serving not as judges, but as justices of the peace, and some in the sentencing process as well. So that's a way, it could be seen two ways. It's either a way to basically complete the assimilation of the Aboriginal people in Inuit, or it's seen positively in a good, from the good side of the medal. It could be a move as telling them that they are listened to, they are included in the judicial system as main actors, as decision makers. They matter. So to go back briefly, because I just want to bring that slide to your attention, but I covered it all already. There's something else here. Just to go back to the different offenses and the transgressions, like the insults and the property offenses, and the fact that some people fail to share food. The way they dealt with it, that's interesting. Here, you will see that these offenses were responded to by such methods as gossip, derision, shunning, banishment. But banishment, let's talk about it for a second. If you're banished in the South, especially in Hong Kong these days where it's pretty nice and warm, I wouldn't mind to be banished from another town and being told, okay, your punishment will be to spend time in Hong Kong. Great! But being banished from a small community covered in snow, in the cold, being alone, it's so small, the population is not really big, you're by yourself, it's serious, and it could lead to death in some cases. Nowadays it still exists, for example, to protect victims, especially for sexual assault cases and spousal abuse cases. A person may be banished, not banished, but necessarily, but may be prevented from being allowed to go to this or that community to protect the alleged victim. But in the older days, that was But nowadays, of course, you have ways to be okay. But the traditional Inuit system, that's a serious thing, being banished in these circumstances of the Arctic and the sub-Arctic in the Northwest Territories. So culture makes a difference when it comes to criminal law. So it's not only a matter of learning a book called the Criminal Code, understanding the sections, understanding the offenses, understanding the crimes. Well, crimes have reasons. Crimes may be different. Crimes, the commission of the crimes may be explained, as we touched upon a bit earlier, may be explained by a cultural background, like it may be in many cases, or some cases at least, for the Inuit and Aboriginal population in Canada. And it's not a trauma, but it's more something that is, let's talk about a bit about the police officers in the North. So the last sentence here of a report that was prepared for the Canadian Police College, it says that these officers are readily available and highly visible. Why? Because usually the police officers, and they were actually, maybe not nowadays, but in the older days, at least in 1985, which is not far back, for so long ago, the police officers were the only white population in the communities. And in Nunavut, I understand, I think that the stats are that about 95 or maybe more, 95% of the population, or maybe more than that, are Inuit in Nunavut. So most, many people, if not most of them, are Inuit. So the whites are the police officers. So of course, yes, we do have a misunderstanding of their culture. We did, and we still do to a certain extent, but they do too, because the only white people they were exposed to so far, for many of them, are police officers. They're not the people who put people in jail, but they're still the people who do represent the state. And they're, like the was reported, they're the symbol of the government failure, misunderstandings, and broken promises by the government of Canada, unfortunately. And that's the only white people that many Inuit saw in their life. So to come back a little bit to the sentencing process, I understand that you're not all law students. So sentencing is the last stage of a criminal law procedure in court. This is when someone is given a sentence by a judge. So the courts, and that's the two decisions in Gladue and Ipoli, which says that, they both say that differently, but in Ipoli, a Supreme Court of Canada decision stated that courts must take judicial notice of such matters as the history of colonialism, displacement. I talked to you about the settlement or the forced relocation of the people, residential schools, and how that history continues to translate into lower educational attainment, etc., etc. So I heard really often saying, Justice Kilpatrick of the Nunavut Court of Justice, he said often, and that's the truth, the Nunavut Court of Justice, that's a Gladue court by default. The Gladue court means that that court must take these principles, not these principles, but these things into considerations in many, if not most cases, because of the nature of the population, who is the population in Nunavut. Like I told you earlier, 95, probably more than 95% of the population is Inuit. So this is something that is systemic. These factors must be taken into account. So you come back a little bit to, and that was the last slide, I believe. Just check here. Just bear with me for a second. Yes, it is. So the elders, come back a little bit to that, because that's a really interesting issue. So there's something that exists in the North that doesn't exist anywhere else in the country. Well, it does when Aboriginal people are involved, but it's really something that comes into play when Aboriginal people are involved as accused, as the healing process. And that's part of the justice in the North. The Inuit population and the Dene population, the Aboriginal people in the North do, and elsewhere, do believe in the healing process. So what it is that what you did can be dealt with by an elder, for example, who will talk to you, will meet you, will tell you, and I heard that so often, and I must be honest with you, as always, of course, that was weird and strange to hear. But the first thing every time that the elder said on the record in court was telling the judge, well, Your Honor, I just would like to know that the accused is loved. The accused just committed a crime. It's horrible. As the guy, myself, as the guy who put people in jail, between quotes, I was horrified by the statement. No, we don't love him. We would like not necessarily to put him in jail, but he's here to be sentenced. So that was completely foreign to me. But I understood afterwards. But again, that's a cultural difference. Why? Because people need to stick together. So of course, if you want to live in harmony, you need to be loved. If you're hated or despised, or if there's gossip going on in a small community of 20, 50, 100 people, that's going to harm the entire population. So yes, you have to be loved. So this is a cultural explanation of this. So the process is really interesting how the Inuit way of the healing process worked with accused. So first of all, the elders start by talking, not in court, but outside of court before the procedure took place. So start by talking to the person and telling him that he's loved, and the elder said that too on the record, but he told him, first thing, you're loved. And then if the person continued to misbehave, the elder would talk to him again and say, no, you cannot do that, or you cannot take something away from somebody else, you cannot punch a person in the face or anywhere else, you can harm people, you cannot do this and do that. And so, and if it becomes more serious, the third step would be that since the person was warned not to do something, now in the third step, the accused would be told, or not the accused, but the person who will be an accused or wasn't accused, will be told to that he will have to suffer from more serious consequences. But that's the difference, that it is major. That's the Inuit way. In the white criminal law justice system, if I pick up a chocolate bar in a store, there's not going to be an elder who's going to tell me that he loves me first and who will try to understand me. And I'm not laughing at the Inuit justice system. Quite the contrary. I'm just giving you a big, obvious example of a major difference. I'm going to be arrested by the police right away if I don't give an explanation to the guy at the cash, and oh, that's a mistake, I forgot, didn't have money, sorry about that. I'm going to be arrested. But this is not how it worked in the Inuit community. So it was worked with the 3 steps stage. First, you're loved. Second, we will talk to you again if you do it again. And then if you don't understand, only afterwards, you will have to suffer more serious consequences. But the white judicial system is right away. Right away. You're arrested and you're brought to the police station. So this is an interesting cultural difference. So all of which to say, to conclude this presentation, is the impact of culture on the criminal justice. And why is it interesting to talk about it in Hong Kong? How could it be used, potentially, is just by the simple fact that cultural differences it does have an impact on the justice system in many ways. So either you accept it and you integrate it, you include it, or you reject it, and then, like Canada did, you do your best to find somewhat of a compromise, understanding the trauma caused by the government in the case of Canada. Or you just don't consider it. You don't reject it, you don't accept it. But culture plays a big role in the case of criminal law and other areas of the law as well. But this is what's the most interesting for people all around the world. It's something that students don't necessarily understand right away when they are studying the law. It's not only studying a book, studying sections after sections after sections. It's not only related to and connected to something that is rational in terms of intellectual notions, but it's also connected. The law and the justice is also could be explained, could be connected to the culture as well. Thank you very much for welcoming me today.
Thank you very much, Mr. Lafrance, for that fascinating overview. You've talked about the differences in the North and the South. You've described it as a compromise. Are there challenges for the principle of equality before the law, equality before the courts? Is that being compromised in what you see in Canada?
Well, as a Canadian, and of course, as having been born under almost born under the Charter, the Canadian Charter of Rights, in the section 15, which is the section that addresses the equality rights. Yes, this is something that was a problem. That's still an issue that the Supreme Court of Canada tried to address in the decision of Gladue and Ipoli, and the equality rights comes into play when your culture is different, not necessarily understood by the government or the criminal law system, and you're treated differently, right? So the Supreme Court of Canada tried and succeeded in understanding this cultural difference and acknowledging that, well, in terms of being equal because of all the trauma, the Aboriginal population, including the Inuit population, should be treated differently. So
a substantive vision of equality.
Absolutely, yes. Yeah. So equality, that's strange what I just said, because what I just said is, well, equality means that people will be treated unequally. And that's good. That's being equal. But if you go a bit further, the fact that the Aboriginal people will not be treated the same way, but with more an understanding eye, means that it's part of the equality calculation here, because of all the trauma that they went through, that the white population, for example, or another people from any other ethnic background, didn't go through these trauma. Well, in terms of being equal, to be considered by the judicial system, the equality means that you have to be treated in a different way. So it's not unequal, but different. So to be on the same level as any other Canadian citizens.
Okay, thank you. Yes.
I have two related questions. Thank you very much, Mr. Lafrance. I think it's relatively easy to make the case and for us to understand that equality doesn't mean identicality. And the cultural differences that you have referred to, it's easy to see how in the context of petty crimes or lesser crimes, it can be dealt with. Shoplifting, trespassing, so on and so forth. But doesn't that really beg two questions? One is, what happens to the harder crimes? How could cultural difference be or not be factored in? So that's the first part of my question.
Can I answer it right away?
Please.
There's a clear answer to that, and I thank you very much for this question. So that's why I allowed myself to interrupt you, because the answer is really quick. So the Supreme Court of Canada, either, I don't remember exactly if it's an Ipoli or Gladue, but what the Supreme Court of Canada said summarily is that the more serious the crime is, the more the punishment will be the same as for any other Canadian citizens. So in the cases of murders, for example, yes, the aboriginal factors will come into play, but not as much as for petty crimes. So there's some kind of a gradual standard, right? So that's the...
And I'm sure it can be justified or explained by some grand theory that human values tend to converge when things become serious. I don't know, that's a different territory. The flip side of that question is, if we think about petty crimes, and sort of day-to-day justice, isn't that in fact better delivered not by you and the judge, but by the white guy who's the police officer and by the justices of peace, because they both stand closer to the community and in many ways they have more discretions. I mean, the police officer has the discretion to say, yes, this is technically trespassing, but let me try to talk the guy into not pressing charges, because if he understood the context, then we can just move on.
Yeah.
And with that, do you feature in that system, or is the system designed such that the guy who put people behind bars just don't even deal with that sort of thing, and we've got to leave it to the mounted police to handle that?
That's a very interesting question, and that's nice, because I'm going to have to be selfish for a little bit and talk about myself. Thank you very much for that question. It's really interesting because it brings me to the daily work of what I'm doing. It's not the same thing in the north as it is in the different provinces. So the police doesn't work necessarily the same way. For example, in one of the Canadian provinces, all the charges must be, before they're laid against someone, they must be reviewed by the Crown, and then it goes in the judicial system. In the north, it doesn't work that way. We're getting calls, we're getting consulted as Crown Counsel from time to time, where the police officers have hesitations about one case or that case, about a legal issue, if it's worth laying a charge for whatever reason, justified reasons, of course, for the most time, in the most occasions, but we are usually dealing with charges when they're laid. So we're in 99% of the cases. And so the police officers have the discretion, and they have a lot of trainings, right, about the Aboriginal reality and the Inuit reality or the Dene reality. So they have to, but in cases of shoplifting, for example, if the owner of the store complains to the police officer, well, the police officer cannot tell the owner, it's fine, it's just a chocolate bar, come on. No, he's going to have to lay a charge, even though he knows that probably if the accused doesn't have a criminal record, that this is something that could simply be diverted, which means that it won't go into the judicial criminal justice system directly, but it will be dealt with outside as a diversion. But they have a lot of discretion about that. But of course, when they have a complaint from someone, unfortunately they have to, even though it's petty crime, and they have to lay a charge. And simply as a matter of, well, as a matter of legal obligation, of course, but also as a matter of respect in terms of common sense principles to the owner of the store as well. But that's interesting to see, but the Crown also has a discretion to divert the case, so sending it to diversion process. So diversion is for people who are not law students here or involved in the study of law. Diversion is something that is that's a procedure that is used that is not in courts. It's usually there are judicial or justice committees which are created. Most of the time, the population or the people sitting on the Justice Committee are Native people, and they will use the same procedure, talk to the person, tell the person it's not a good thing to do, and they will, more than that, of course, they will put some kind of ongoing work with that person to make the person aware of the wrongdoing in such and such case. But yeah, so there is not a clear answer. There is, but to the extent where usually we don't, and the police officers don't play they have to lay charges in many cases because there is a complaint, but they have the discretion not to if it's not a complaint and they were just picked up someone and the spur of the moment, and it's petty crime. They know the guy, they know the community, right? The RCMP officers usually remain in a community for 2 to 3 years, so they get to know the people. And of course, being small communities, they know pretty well everybody quite quick. Not because they're criminals, but they know the population who are not criminal as well. So they become, like I told you earlier, the representative of the government, because I don't go to the small communities and my colleagues don't go to the small communities all the time. We fly in and we'll fly out after the court's done. Same for the judge, same for defense counsel. So the only symbol of justice, if I may say, is the police officer or the police officers.
Just to follow up on that point, so if that is the case, do you think that the Gladue principle should apply to the police, in the sense that in recent years we've been seeing a rise in mandatory minima that restrict what you can and cannot do as the prosecutor, and as the Supreme Court recently ruled, the Gladue principles do not apply to the mandatory minimum process. So really your hands are tied in how this process unfolds in the court. So how does this, what's the interplay then between Gladue mandatory minimum sentences and the police officers who, as you suggest, are the symbols of justice in the community?
Well, let's take an example, the impaired driving cases. There is a mandatory minimum for these cases, mandatory punishment. So just for the benefit of the other people in the room, mandatory minimum is, for example, one person is driving and was drunk and it was over the legal limit and get arrested. So if it's a second time offender, the crown is tied, our hands are tied, and we have to ask for a minimum of 30 days in custody. So we cannot say, well, it's all good. That's a person applying the Gladue principles or IPLE principles. Let's not go with the mandatory minimum. Let's just, that person is a good person. He didn't mean it. He suffered from the residential schools. He was sexually assaulted by the priest when he was young. So let's not go with the mandatory minimum. Let's go with that is a jail sentence for a second time offender. Let's go with something else. Let's go with, I don't know, conditional sentence order or probation or whatever it is. Unfortunately, we can't. We're really, our hands are really tied. We have to apply and follow the mandatory minimums. So that's an interesting issue, actually. But they don't apply the Gladue and IPLE principles, indeed, when it comes to mandatory minimums. But the question remains. The Supreme Court said that it doesn't apply as a matter of legal principle, but when it comes to, does it make really sense in terms of moral justice, if there's one, or in terms of principles, philosophical principles? That's something that would be really interesting to be looked at, for sure. Because why? Why? Yes, the code says it, and that's what the legislator decided. So in pure terms of what the law says, and a positive approach to the law would tell you, well, that this is what the Supreme Court stated. This is what the criminal code said, a mandatory minimum of 30 days. What are you talking about? Yeah, fair enough. But if the person was drunk and driving, but there are some cultural explanations, so why the IPLE and Gladue principles that the cultural background or experience, unfortunate experience that I talked about earlier, why shouldn't it apply? So that's...
I think the question is more about, should Gladue, although it can't apply to a mandatory minimum, should it inform discretion, whether it's the charging discretion by police or the prosecution discretion by yourself?
Oh, yeah, okay. Yeah, the answer is more straightforward for this. In cases of impaired driving, for example, the police officers will definitely lay a charge. For weapons, for some weapon offenses, there is some mandatory minimum. So when there is a mandatory minimum, it's usually for more serious offenses. Drunken driving, that's another decision of the Supreme Court of Canada, and Stellato, S-T-E-L-L-A-T-O, that's something that's taken seriously by the courts all over the country. But for any other serious offenses, possession of, well, not possession of weapon, but some other, there is Section 92 of the Criminal Code, Canadian Criminal Code, that is about weapons. There are other mandatory minimums. Can the police just say, oh, poor guy, let's forget about it? They will, usually will, well, they have to, they will their charge. Because the underlying explanation is that if there is a mandatory minimum, it's because it's a more serious offense. So that would be a way to justify it.
But what about prosecution? There may be sufficient evidence, but you may say it's not in the public interest.
That's right.
And not prosecute.
Yeah, the Crown Counsel have this two steps analysis that we do. So the first step is the reasonable prospect of conviction. So that's the first stage of our analysis. So when we have a file on our desk, a criminal law charge is laid, any section ends up on our desk, we have to look at the case of the facts, determine is there a case. So that this is what reasonable prospect of conviction means. So even though there's a case, like Professor Young just said, is it really in the public interest to prosecute here? So yes, there could be a case, but is it really in the public interest to do it? So we have to turn our minds to these issues. And public interest is quite complex. I'm not going to talk about it in length today, but it involves many factors. But this is something that our minds must be turned to and make sure that we have a look at it for every single case. That's an obligation for the Crown Counsel in Canada.
Any other questions? We have time for one more.
One quick question. In this kind of small community, do you have difficulties in finding a witness to testify against another? Or a co-defendant, for example, given that they're going to be so close to each other?
Okay. So
either relationship-wise or within the physical context.
Okay, I will ask you a question back before answering a question. Did somebody pay you for asking these questions? Because that's amazing. That's an amazing question. I really wanted and dreamt about this question. So thank you very much for this question. The answer is yes, yes, and that brings us to another cultural issue. So to summarize, to sum up your question would be to say, is there any problem to find out or reach the witnesses for a case so you can have a trial because they will have to testify for the Crown's case in Canada? That's how it goes. We have to bring the evidence and call the witnesses to the stand to testify about a case unless the evidence is admitted by defense counsel. Is it tough to find them? Is it tough to have them in court? Oh yes. Why? The pressure, sometimes the pressure of the community, because the community tells you, oh, don't, not necessarily to be mean or bad, but the Canadian judicial system is still seen as the white criminal justice system. So it's still, sometimes you can feel it. It's almost an impression that I'm talking about right now. It's really my personal view, but you can almost physically feel it, that there's this fear of the, not fear necessarily all the time, but they don't necessarily trust you. Because you don't go there often, you're not part of the community, so why would they? You're just coming there to put people in jail. So many people don't show up. That's very sad. But pressure from husbands or wives, depending in this case of spousal assaults, because the community is so small that the community tends, or maybe they do something all together in the community and try to deal with that and tell the person don't show up. Or the alcohol abuse is so heavy that the witnesses may be drunk on the day of the trial. It happened to me several times. So of course you're not going to call to the stand someone to testify when he or she is close to pass out because of alcohol, because her evidence or his evidence will not be believed in any way. If I don't believe the person, how can the judge believe that evidence? And the pressure of the community That's the keywords to answer your question. Thank you very much again. That's sort of. So what does it mean? Why is there pressure from the community? Again, the survival factor. So you have to stick together in harmony to make sure that the future will be bright and not darkened by hate, by and something else. The Inuit, I don't know about the Denes though, so that's another community in the Northwest Territories. The Inuit is mostly Nunavut, but the way they approach things is and when I say they, it's only general. I just generalize things, right? So they include our notions. They have their own personal view on things also. But as a general statement, as a cultural thing or factor, they tend to forget about the past. So I heard that several times. Why would I testify? It happened 2 weeks ago. Now we're okay. Yes, he or she punched me, but now everything is fine. She or he works on getting better. So again, the Crown Counsel, the people who put people in jail, looks for deterrence and denunciation to punish that person, the accused, whereas rehabilitation or the present time is more important for the Inuit and or the original people, and they want to forget about it simply. So it's not only it's a cultural difference. Many white, Asian, African people will tell you or may tell you the same thing. Oh, it's 2 weeks ago, it's fine. But that wouldn't be for the same reason. The Inuit people will tell you this because, again, they have this history of, and recent history. It's not 3 centuries ago. It's more recent than that. It was still in the 20th century. So small communities. So they have to find ways to make it work, to survive because of the tough kind of weather conditions, the tough, not only the weather conditions, but the land. And they have to bear with that and make sure it's going to work out for everybody, right? So yes, it is tough. I thank you very much. That's an amazing question.
Well, on that note, I think we'll bring this seminar to a close. In Hong Kong, we constantly fret about one country, two systems, but I think you've told us a very fascinating and interesting tale of one country, one system, and two cultures, and how the one law applies to these two cultures, I think is absolutely fascinating. So thank you very much, Mr. Lafrance, and on behalf of CCPL and everyone here, thank you again for coming.
Well, that was that.
Your questions were good too.
I can imagine the practicalities of things must be really different.